Good morning to everyone on the West Coast, and good afternoon to everyone on the East Coast. Thank you for joining us for our second quarterly webinar. This is Martin DeZoor of DeZoor Compliance Consulting. I serve as the Chief Compliance Officer for IMST and IMST2. As a reminder for those who haven't been able to join us for our first webinar, we're holding webinars going forward as a joint effort between your service providers, MFAC, UMB Fund Services, Tate Weller, and DeZoor Compliance Consulting. These webinars will be held on a quarterly basis going forward, and we'll cover a different topic each quarter. I will start off today's webinar, which will be covering the 15C contract renewal process. We know that we ask all of you for a tremendous amount of information and want you to understand the importance of this process. Our panelists today all are from FMAC: Rita Dan, Diane Drake, Sarjo Kitteman, and Amy Gwendon. FMAC works very closely with the trustees and legal counsel to coordinate the flow of the 15C information. If you have any questions throughout the webinar, please type them in the question box on your webinar control panel. As time permits, the panelists will answer your questions at the end of the presentation. If we do not get to your question during the webinar, we will contact you separately. To begin, Diane Drake will provide some background information on Section 15C of the 1940 Act. Thank you. Diane?
Thank you, Marty. I'm going to begin by providing an overview of Section 15C of the 1940 Act and discuss trustees' responsibilities in reviewing and approving advisory and sub-advisory contracts. Please note that under the 1940 Act and for today's discussion purposes, the term advisor also includes sub-advisor. Section 15A of the 1940 Act prohibits any person from serving as an investment advisor to a mutual fund, except pursuant to a written contract that must be specifically approved . Okay, Diane had to drop off. This is Joy, and I'm going to step in. So as she was saying, except pursuant to a written contract that must be specifically approved annually by the Board of Trustees at an in-person meeting. The contract must be approved by a majority of the Board of Trustees, including by a vote of the majority of the independent trustees. And the contract must be approved in person by the trustees at a meeting called for the purpose of approving the advisory contract. Trustees are subject. Okay, thanks. Thanks, sorry about that, a little technical difficulty. Trustees are subject to the specific duties imposed by Section 15C to request and evaluate such information as may reasonably be necessary to evaluate the terms of the advisory contract at issue. Interestingly, Section 15C does not outline specifically what information must be requested of the advisor and evaluated by the trustees. In addition, Section 15C of the 1940 Act does not state what factors the trustee should consider in evaluating an investment advisory contract. The purpose of the 15C annual review of the fund's investment advisory contract is for the trustees, as representatives of the shareholders, to determine that the advisory arrangements are fair and reasonable relative to possible alternative arrangements, and that the advisory services that are being provided are in a satisfactory manner. Our trustees have a responsibility to act with a duty of care and a duty of loyalty to the fund shareholders. With respect to duty of care, trustees are required to act with reasonable care and skill in light of their actual knowledge and any knowledge that they should have obtained in functioning as a director. With respect to duty of loyalty, trustees are required to refrain from engaging in personal activities that would injure or take advantage of the company. In addition to the fiduciary duties imposed by state law, trustees on investment are subject to fiduciary responsibilities under the 1940 Act. In particular, trustees must monitor potential conflict of interest situations. Independent trustees have a responsibility to represent the best interests of shareholders, thereby assuring that the fund operates for the benefit of the shareholders rather than in the interest of its advisor, underwriter, interested trustees, or other special groups. In determining whether to approve an advisory contract, trustees have a duty to become fully informed and to exercise their independent judgment consistent with their fiduciary duties. This means that trustees should act in good faith, with fairness, and with an honest belief that the proposed transaction is in the best interest of the fund and its shareholders. In making its determinations, trustees may rely on information presented by others, including officers and employees of the company, counsel, accountants, and other experts. There have been many lawsuits challenging an advisor's fee as excessive. Today, we're going to focus our discussion on the decision in Gartenberg versus Merrill Lynch Asset Management. This case is among one of the first excessive fee cases which provides best practice standards that are recognized by the courts and the SEC. I would also like to note that more recent cases have involved a review of the trustees' review process in approving an advisory agreement. So it is very important for trustees to request and receive appropriate information in making their determinations. By way of brief background, in Gartenberg, shareholders in a money market fund challenged as excessive the management and advisory fee of the fund's advisor. In affirming the decision of the district court that the fees were not excessive, the appellate court considered a number of factors, including the advisor's profitability. The court concluded that, in light of the circumstances and evidence presented at trial, the advisor's after-tax profit, which in this case was 38%, was not excessive. There are no rules as to what is a fair fee schedule. A basic test developed through the excessive fee cases is essentially whether the advisor's fee schedule represents a charge within the range of what would have been negotiated at arm's length and in light of all the circumstances. Receipt of a fee that is so disproportionately large that it bears no reasonable relationship to the services rendered and could not have been the product of arm's length bargaining would involve a breach of the fiduciary duty by the advisor. In Gartenberg, the court identified the following 5 factors in determining whether this standard has been met. First, the nature, extent, and quality of services provided by the advisor. Second, a comparative analysis of advisory fees paid by and the expense ratios of other similar funds, as well as advisory fees that the advisor or sub-advisor charges other types of accounts with similar investment policies. Third, the cost of the services provided and the resulting profits realized by the advisor from its relationship with the fund. Fourth, the extent to which the advisor has realized economies of scale through growth of fund assets. And fifth, follow-up benefits to the advisor in managing the fund. Our annual 15C information request sent to each of you was developed with these factors in mind. The goal is to provide detailed considerations regarding each of these factors. Now we're going to discuss each factor in more detail. First, the nature, extent, and quality of services provided by the advisor to the fund and its shareholders. This factor focuses on a fund's investment performance. However, it may also take into account other services provided to the fund by the advisor, including the advisor's research, portfolio management, trading, investment controls, and legal and regulatory compliance. The trustees consider the experience of the professionals managing the fund, as well as the experience of any sub-advisor to the fund. In addition, the trustees consider the adequacy of the resources of the advisor and how the advisor's financial condition affects the nature and quality of the advisor's services. The trustees will also consider whether there have been any compliance or other problems in the management of the fund apart from performance, such as code of ethics violations, fund compliance issues, and repeat SEC deficiency findings. The trustees will review the advisor's oversight of any sub-advisor and whether that sub-advisor has any compliance issues or problems in the management of the fund. Next, comparison of advisory fees and expenses to those of similar funds. The trustees must evaluate each contractual advisory fee rate to determine whether it is fair and reasonable. It is also appropriate for the trustees to review comparative information concerning total expense ratios, and the impact of contractual fee waivers and expense reimbursement arrangements, since these reflect the bottom line cost to shareholders. Fee comparisons are the primary available means of evaluating the cost of possible alternative arrangements. Our trustees review materials prepared by Morningstar fee comparisons with the fund's peer group and fund universe. Therefore, it is very important that you review the peer group assigned by Morningstar for appropriateness. In addition, trustees may take into consideration advisory fees charged to your other types of accounts, even if there are significant differences between the services provided to the fund and those provided to the other types of accounts. Now I will turn the discussion over to Rita, who will discuss the other factors.
Thank you, Diane. The next Gartenberg factor is the advisor's cost for providing services to the fund. The cost information are then compared with the revenue you receive from the fund in order to assess your profitability from the fund. In the next slide, to assist the board in evaluating this factor, included in the information request package is an Excel spreadsheet for you to report your profitability from each fund. The worksheet is essentially a P&L. The first section of the worksheet is to report your advisory fee, which is your revenue. On the top section, we have the average net asset number, and that is used to calculate your advisory fee from the fund, which is a straight calculation by taking the contractual management fee multiplied by the average net asset. These two figures are usually included in the spreadsheet already. The second section is to report your cost for providing services to the fund. Potentially, there are three types of costs. First is your cost for providing portfolio management services, which may include your compensation for the portfolio management team, including analysts, research personnel, your trading department costs, or compliance costs. Please only include costs relating to providing portfolio management services. Please do not include any costs related to your distribution or marketing efforts to raise fund assets. And in connection with this cost line item, we also ask that you complete the bottom yellow highlighted section of the spreadsheet. So on the left-hand column, please check the appropriate boxes to indicate your cost allocation methodology. And then on the right-hand side, we also ask you to fill in the percentages of the fund in relation to your firm. So for example, if you allocate your cost based on revenue, and on the right-hand side, you should fill in the fund's revenue as a percentage of your firm's total revenue. The next Gartenberg factor, the fourth factor, is economies of scale. Economies of scale is a two-part analysis. First, you should determine whether any economies of scale exist. Generally, it is reasonable to take the position that economies of scale do not exist for funds with small asset size, where you're still subsidizing the fund either by waiving a portion of your fee or making reimbursement payments to the fund. And the second part, if it was determined there is economies of scale, whether the advisory fee schedule fairly reflects such economies of scale in the form of breakpoints in your management fee at the higher asset level. So in the next slide is a sample Morningstar report. Inside the Morningstar report, this is the page where it compares your advisory fee with peer funds at different asset levels. So this page gives you some idea where your fund lines up against your peers. The economies of scale factor is not so much about whether your fees are higher or lower than your peer, but it's really more on the fact whether you realize economies of scale in managing the fund's assets. And if yes, there is expectation that some of that get passed down to the fund shareholder by putting in breakpoints in your fees at the higher asset level. I mean, as you can see from this sample report, it is quite common practice to have breakpoints, especially when it gets to the 1 billion or above asset range. I mean, there are funds out there, or including your funds most likely, that does not have breakpoint. It's a flat fee because the fund is still relatively small and doesn't seem relevant at the moment. But usually when a fund does get up to that billion asset size range, the board will have, usually a discussion with you putting in breakpoints at that time. So moving on to the fifth Gartenberg factor, fallout benefits. Fallout benefits are indirect profits, including any other revenue source you receive simply by being an advisor to the mutual fund. Under Gartenberg, quantifiable fallout benefits to the advisor should also be taken into account in determining the advisor's profitability. 3 quantifiable fallout benefits were identified in the Gartenberg case. The first is certain broker transactions, second, float income, and the third, free credit balance interest. I will briefly just cover the first one, brokerage commission transaction, because that's the one that's relevant here. And this has to do whether you as an advisor received any quantifiable extra benefits, either in research or other brokerage arrangement you otherwise would not have gotten if you were not making portfolio transactions for the mutual funds. The other 2 fallout benefits cited in Gartenberg, flow income and free credit interest balance, has to do with that advisor providing transfer agency services to their fund, which are not relevant here since you only provide portfolio management services in the multi-series trust. So next, I will turn it over to Sargento Kataman, who will go over the Morningstar methodology for compiling the fee comparison report, which is an integral part of the 15C process.
Thank you, Rita. Hi, everybody. I am MFCC's main point person to work with Morningstar to create and finalize the peer comparison reports for your funds. We thought it would be good for me to share some insight that I have obtained over the past few years working with Morningstar. As Diane discussed earlier, Section 15C of the 1940 Act requires the approval of the advisory agreement by a majority of the independent trustees. After the initial 2-year term, the trustees are required to review and consider the continuation of the agreement every year at the in-person meeting. The review, consideration, and approval is referred to as the 15C process. The trustees are there to represent the shareholders' interests. Therefore, the 15C process is crucial to make sure that there is enough documentation to substantiate your advisory fee. I would also like to note that the 15C process will protect you, the advisor, in the event a shareholder brings an excessive fee claim your way. As you learn, the trustee must evaluate each fund's advisory fees and total expenses to make sure the fees are reasonable. The trust has engaged Morningstar to assist the board in evaluating those fees, making sure the fees are fair. One of the benefits of using Morningstar is that they are a third-party provider, meaning they are uninterested with no potential conflict of interest in preparing the reports. In addition, they are a respected industry standard. Morningstar prepares the peer group analysis so that the trustees are able to effectively evaluate your fund's advisory fees, expense cap, and performance information. Now, most of you are familiar with the Morningstar 15C report. So how does Morningstar go about selecting a peer group for your fund? Morningstar uses 3 main factors in its peer selection methodology: similar investment style, similar expense structure, and similar asset size. First, Morningstar identifies funds with similar investment style. This is probably the most important factor when they select a peer group. Morningstar reviews your fund's holding based on the annual and semi-annual reports and assign it to a category. From this category, Morningstar select peer funds that are similar based on the security holdings. This is important because funds in the large cap value and small cap growth categories will experience returns that are far apart and out of sync with one another. Similarly, government bond funds and high-yield bond funds will respond differently to the same economic condition. On the expense side, large cap fund tends to have lower expense ratio than small cap funds. And if you have international fund, you'll notice that international fund tends to have higher expense ratio than domestic fund. It is imperative for both the performance and expense comparisons that the peer funds invest in the same styles as the subject fund. The second factor is the similar expense structures. Fund shares come with different expense structures, such as Class A, Class C, and Class I, or institutional class. To ensure a fair comparison for the subject fund, the selected peers should have the same basic expense structure as the subject fund. For example, if the subject fund has the 12B1 fees, Morningstar will select peer funds that also have 12B1 fees. If the subject fund has a front-end sales load Class A shares, then the peer funds are also Class A shares. Using the same expense structures establishes that the comparisons are relevant and meaningful. The third factor is a similar asset size. A significant factor in the fund's expense ratio is asset size. Many of the expenses of running a mutual fund are fixed. Therefore, funds will experience economy of scale as they grow. A $10 billion fund should have lower expense ratio than a $10 million fund, all other aspects being equal. Once Morningstar has a set of peer group candidates that pass the investment style and expense structure process, they will narrow the peer group down by looking at the asset size of the peers closest to the subject fund. Normally, Morningstar will select between 15 and 20 peer funds, depending on the category. Now, the next slide is important. Advisors' feedback. Keep in mind that Morningstar will accept feedback from advisors. MFAC will assist you by opening communications with Morningstar with your feedback regarding the peer fund selected. For example, when you review the initial draft 15C report, perhaps you identify there are few funds that are not appropriate and should be excluded. Or maybe you would like to add 2, 3, or 4 funds that you believe should be included. MFAC will reach out to Morningstar and present your feedback. At the end of the process, all should be in agreement with the selected peer group. In this case, you, the advisor, should detail the reasons why the peer group is not appropriate. In some isolated cases, it is impossible to find an appropriate peer group. Perhaps your fund is unique and there is just not a right category for the fund. We can coordinate calls between you and Morningstar. Please keep in mind, when we email you the draft 15C report, please review and let us know as soon as possible so that we can start the communication with Morningstar if necessary. This Morningstar 15C report is a meaningful tool for the trustees in their consideration of continuing your advisory agreement for another 1-year period. You may be wondering how and when Morningstar review the funds category. Morningstar engages in a formal category review process twice a year, in May and November. For any funds less than 1 year old, additional review is also conducted in February and August. Morningstar has this quantitative filter that proposes category recommendation based upon the 3-year trailing portfolio statistics. They look at the fund statistics like holdings, asset allocation, market cap, value growth score, and duration. The recommendation for changes to existing category are then reviewed by the manager research analyst at Morningstar, who either accept or reject the proposal. If Morningstar proposes a change to the fund's category, they'll email the advisor with ample time to challenge their opinion. If you do not respond, they'll assume you agree with the new category. If you disagree and appeal, then they will review your case. It is important that you agree with the 15C report and the peer group selections. Why? Well, as you know, there are some questions in the legal 15C questionnaire that you need to answer that is relevant to the 15C report. Do you agree with the category assigned by Morningstar? Is the peer group appropriate? You will need to provide a detailed explanation if your fund's returns falls in the lowest quartile in the peer group, or if the fund's benchmark outperforms your fund. If your fund's expense ratio or advisory fee falls in the highest quartile, or it happens to be the highest, you also need to provide explanation. Next, Rita will discuss about shareholder report disclosure.
Thanks, Sarge. Shareholder report disclosure. So the SEC then now requires that the board consideration of those Gartenberg factors in approving your advisory contract be disclosed in the fund's next semi-annual or annual report. The disclosure is prepared by fund counsel, and MFAC gives you a draft to review before it goes into the final shareholder report. Under industry best practice standards, the board makes their deliberation of the 15C information you provided without the presence of representatives from the advisor. So this disclosure documents their discussion of each of those 5 factors and does go into some great detail. For example, if your advisory fee is above the peer fund median, it will say that in this disclosure document, and then it goes on to discuss how the board addressed that point. So it does give you some insight into the discussion that took place after you or your representative has left the board meeting. And also, please remember that the fund semi-annual and annual report, including this disclosure, are filed with the SEC, and they are posted on your fund's website, so they are publicly available. Going on to the next slide. As Diane mentioned earlier that there are abundance of excessive fee cases brought against advisors, there are a number of SEC enforcement actions against advisors and a few on fund boards on the 15C process. I'll touch on a couple of the more recent cases. In 2015, the SEC took enforcement action against an advisor for providing incomplete and inaccurate information in their 15C material provided to their fund board. And some of the deficiencies cited are advisor's failure to provide all of the financial statement requested by the board, neglected to describe its cost allocation methodology in the profitability analysis as requested by the board, and inaccurately represented that their fee schedule for the fund contained breakpoints when in fact they do not. The SEC also charged the board member of that fund group for approving the advisory agreement without having all the information they requested as reasonably necessary to evaluate the advisory contract. In another case, also from 2015, the SEC charged an advisor for providing faulty cost allocation information regarding its profitability. The SEC cited that the advisor changed their method of allocating certain costs so they can show the board a certain profitability percentage, and they did not disclose this cost method change to the board. So these recent SEC cases reiterate that the 15C process is an area of focus during their exam. And you as an advisor to register a mutual fund, the SEC would include in their exam information request some item related to the fund. And based on our past experience, one of those items on their request list is that you provide to them the 15C material you submitted to the fund board. So as a reminder, please keep very good records of the information that you reported in your 15C material, especially documentation on the cost information that you reported on the profitability worksheet. Because during the exam, they will ask you to substantiate that cost number or explain why you selected a certain allocation method. I mean, the SEC comes around every 3 years or so, and it will be hard to remember how you came up with that number or allocation percentage a few years later if you don't have good documentation. And this will also give the staff a base to potentially cite you for providing inaccurate information, or maybe worse, for giving false data if you cannot show proof. And it's because of the public disclosure of the board's considerations and the SEC focus, we at MFAC comes back to you with requests to either revise your response or provide additional information before the board meeting, and sometimes even after the board meeting, we come to you with follow-up requests from the board. This is so there is a complete set of clear records of the information provided to the board and which will benefit all parties involved at the end. With that, I will turn it over to Amy Gwendon to talk about the 15C process.
Great, thank you, Rita. So in this last section, I'm going to discuss the 15C contract renewal process from an operational standpoint. So as most of you are familiar with, at the end of each quarter, MFAC emails the 15C information request to the advisors who are scheduled to renew their contract at the next board meeting. So for example, if you are scheduled to renew your advisory agreement at the June board meeting, you will receive your request for information after the March 31st quarter end. Please note that information requests for sub-advisors are sent to the advisor to distribute to their sub-advisors. So if you have any advisor-sub-advisor relationship, it is important that you work out your delivery process with each other ahead of time. Your responses are typically due no later than 4 weeks after the request from MFAC was sent. Of course, the due dates will fluctuate in relation to the meeting dates, so please pay particular attention to the due date listed on the first page of your request. Once we have received your responses, MFAC thoroughly reviews your answers. We look for things like formatting issues or incomplete responses. So for example, if there are 3 parts to a question, we check to make sure each part has a response. We also attempt to identify responses that are typically deemed insufficient or require revisions per the instruction of either trust legal counsel or the Board of Trustees themselves. Once all of MFAC's revisions have been addressed, the revised responses are then submitted to trust legal counsel for a secondary review. And we do all of this ahead of time to help you put the best product in front of the board. The board book with your responses is released to the trustees 2 weeks prior to the starting date of the meeting. Any materials that are not available to be posted to the board book at that time are subject to extra scrutiny by the trustees before they can be included in the book. This means that if your responses are not received by the due date we provide, the review process is delayed and will often lead to your materials not being ready by the board book posting date. So again, please pay attention to the initial due date and be prepared to respond as quickly as possible to any suggested revisions that are sent to you. So next I want to go over some types of responses that we find consistently require revisions. So for any questions pertaining to advisory fees and expense caps, if your advisory fee or expense cap is higher than the average of your peers, be sure to explain why. And keep in mind that the board does not consider good performance alone as an acceptable rationale for higher fees. Now, I know Sarge already touched upon this topic earlier in a presentation, but just to reiterate, when you receive the Morningstar reports for your fund, be sure to review the category and peer group for each fund very carefully. If you disagree with the category or peers, please communicate this to MFAC right away so that this can be addressed with Morningstar. Also, when responding to the question about your benchmarks, you must provide an explanation for any underperformance in any period. Another area we often need to follow up on is the financial statements. First off, it is important to remember to include the financial statements with the submission of the rest of your materials. If you can, include the last audited financials for your firm, as well as the unaudited year-to-date financials. The trustees review your financial statements to verify that your firm can continue to operate and provide investment services to the fund. In addition, the trustees want to ensure that there is no potential danger to the shareholders that you are unable to pay your contractual expense reimbursement to the fund. If your financials show a loss or significant liabilities, be sure to contact your representative at MFAC in advance to discuss the appropriate options for responding to these questions. Also, formatting issues are a fairly common problem we see. First, be sure that the full and complete question is included before your response and that the questions and responses are properly numbered. And note that the 15C information request is constantly being revised to keep current with SEC rules, guidances, and board focus. This means that questions may be updated, improved upon, or added and subtracted. And we understand it is efficient to use your responses from the previous year, but please be sure you're responding to the current questions. Second, the information you provide should be in clear, easy-to-read format. If we have asked for 4 to 5 different performance periods, please provide performance for those requested periods in a nice, clear table. Another possible idea is to use different color fonts for your responses. The next one is an important one. Please refrain from using C attached for any response if at all possible. We typically see this type of response when the question pertains to your firm's cybersecurity, compliance procedures, BCP, etc. It is very important that you put your answer directly in the responses you are submitting, as the trustees may not be able to interpret the answer you're trying to convey from a separate 200-page document. The only exceptions to this are the profitability analysis, financial statements, and any SEC letters. Next, when referencing your fund in your responses, please do not use ticker symbols. With so many funds in the trust, please understand that it can be difficult to recall each specific ticker symbol for each fund and class. Lastly, advisors should only answer 15C questions for your funds that are scheduled for contract renewal. If you have new funds or if there was a change of control that resulted in a new advisory agreement, your fund may still be within its 2-year window and does not need to renew. We do not want to overwhelm the trustees with more responses than are necessary. And your information request will indicate which of your funds are being considered for renewal at that meeting. So for example, you may have 4 funds, but only 3 of them are scheduled for renewal, so you only include information about those 3 funds in your 15C responses. You will, however, need to include information for all of your funds in the in-person presentation. And lastly, please be sure to complete all of the appendices in the information request. And this includes the annual review of the compliance program. The Board of Trustees needs all of this information to determine the renewal of your contract. And the only exception to this is Appendix C, the Distribution, Shareholder Servicing, and Subtransfer Agency Fee Questionnaire, If none of your funds have a shareholder servicing plan or a sub-TA fee, then you do not need to complete this appendix. However, you do still need to complete the executive summary template you are sent. MFAC is always here to help make this process go smoothly, so if you have any questions, you can reach out to your client service representative at MFAC, and they are more than happy to help you. And now we will go ahead and take some questions. Let me see here. All right, so we have a few questions. I'll just get to them in no particular order here. My firm is privately held and I don't release financial information to anyone. Is this a problem? Diane, do you want to go ahead and take a stab at that?
Sure. MFAC and the board understand the confidential nature of materials that are provided to the board in relation to the 15C renewal process, and we make sure that we take appropriate steps to protect that confidential information by only providing it to those who need to receive it, particularly the trustees. Part of the board's analysis to make sure that the advisor has the financial capability to provide appropriate services to the funds. So therefore, the advisor's financial statements and the profitability must be provided to the board.
Okay, great. Thank you, Diane. The next question we have here. Morningstar does not have an appropriate category for my fund. What should I do? I'll go ahead and have Sarge answer that question.
Thank you, Amy. I think we still got on time here, so I'll try to be brief. Morningstar does not have appropriate category for my fund. I'm going to try to answer in a two sections. The first one, let's just say you notice that your fund is misclassified. When you go to morningstar.com, you see the fund. You see that your fund is in the market neutral category, but you believe that it should be in the long short equity category. Morningstar has this a form. It's called appeal form. It's a 1-2 page appeal form that you need to complete and send to them. They'll review your case, and if they agree, they'll change the category. I think the case may take up to 1-2 months for it. Please reach out to us. We have a copy of the form, and then we can email that to you. The second part, which is I think is more important, is regarding the category for your 15C report that you and the board will be reviewing. Again, I'm gonna throw another example. I think it's better for the visualization here. Let's just say you have an all cap domestic fund, and then Morningstar look at the 50% of your portfolio in the large cap, and the 50% is kind of mixed between mid and small. They'll put you in the large cap growth fund. When they review when they prepare the 15C reports, all the peers is large cap growth, but you invest in the all cap. So Morningstar does not have all cap category. So you believe that, you know what though, I think we should throw in some mid and growth and small in this category because of my all cap culture. So that's something that you reach out to us, and we'll go to Morningstars and we'll revise custom peer group, which is doable. So this is, I mentioned earlier a little bit today that it is very important that you need to agree with the peer group selected by Morningstars. Again, if you have any questions, reach to any one of us.
Great. Thanks, Sarge. All right. So it looks like we only have time for one more question here. So for the profitability spreadsheet, is it a bad thing if it shows a negative profit? So I think Rita is going to go ahead and answer this one.
Okay, yeah, that's a good question. Please keep in mind the profitability spreadsheet is to show your profitability from the fund. And if the fund happens to be small and it's operating, above the expense cap, you probably are waiving your fees and making expense reimbursement payment, and that's why you have a negative profitability shown. And in those scenarios, it's expected, so I wouldn't categorize it bad. But then this sort of tie into the earlier question about giving financial statements. So that makes, the financial statement even more relevant to the board. in order for them to assess your financial capabilities. Otherwise, it begs the question, if you're losing money from this one product, can you continue to operate? That's the only information the board has. And as Diane mentioned, it's already, established that your financial statement is a relevant piece of information for the board to approve your contract.
Great. Thanks, Rita. So that is all the time we have for questions. We will send out the PowerPoint slides, a recording of the full presentation, and a summary of the Q&A session to all of the participants in the next day or two. And now we'll go ahead and hand it back over to Marty to conclude our webinar.
Thank you, Amy. Those were some interesting questions. First, I would like to thank our panelists from FMAC. Also, a thank you to all the advisors and sub-advisors for joining us today. We know that everyone is very busy, and we appreciate your focus on the 15C process. We acknowledge that this process is time-consuming and cumbersome, but I hope we have highlighted in this webinar it is extremely important and deserves the extra time and detail. The time you spend today will be much less painful than down the road if one of your shareholders ever brings an excessive lawsuit against your fund. If you have any additional questions, please contact any of the panelists or me. Also, you'll be asked to complete a short survey on today's webinar to help us on conducting future webinars. Thank you again for your time today. We look forward to the next webinar.